Start. The bench cautioned that the exercise of power under Article 227 must be done to ensure that the courts and tribunals function within the bounds of authority and the law, but the High Court must not interfere to correct mere errors in law or fact, or just because another view than the one taken by the tribunals or courts subordinate to it, is a possible view. The petitioner-plaintiff petitioner, while recounting the facts of the case, stated that they were tenants of the suit property and were in lawful possession of the same. Further, an agreement to sell was executed between the petitioner and the defendant for the suit property, and part payment worth INR 1000 was made in 1985. However, due to the death of the president of the Mandali, the sale deed could not be executed. The petitioner claimed that the lower courts have disregarded these facts and documents. Accordingly, the First Appellate Court also directed an auction of the suit property while disregarding the possession of the suit property by the petitioner for several years. Therefore, the petitioner sought the exercise of the High Court's jurisdiction under Article 227 to remedy the aforesaid errors in law and fact by the subordinate courts. As regards to the agreement of sale was concerned, the bench concluded that the father of the petitioner had not taken any step towards the execution of the sale deed. Further, the petitioners have not furnished any evidence to establish their possession of the property, nor have they affirmed the same on oath. The petitioners have also not produced any rent receipts to establish that they are the lawful tenants while the property belongs to a Mandali. The interim relief sought by the petitioner was in the nature of final relief, which could not be granted by the lower courts. The bench also refused that the ingredients of interim injunction were satisfied. The bench, while relying on the Shalini Shyam Shetty and another versus Rajendra Shankar Patil in 2010, 8 SCC 329 judgment of the Supreme Court, concluded that the frequent exercise of the High Court's jurisdiction under Article 227 is counterproductive. The jurisdiction under Article 227 is entirely discretionary and no person can claim it as a right, while the exercise of power under Article 226 is claimed as ex debito justitia or as a matter of right. Further, relying on the case of Shalini Shyam Shetty in Supra, it was reiterated that under Article 226, High Court normally annuls or quashes an order or proceeding, but in exercise of its jurisdiction under Article 227, the High Court, apart from annulling the proceeding, can also substitute the impugned order by the order which the inferior tribunal should have made. It, however, cautioned that the exercise of power under Article 227 must be done to ensure that the courts and tribunals function within the bounds of authority and the law, but the High Court must not interfere to correct mere errors in law or fact, or just because another view than the one taken by the tribunals or courts subordinate to it, is a possible view. Over.